Okay, well, let's get started. Welcome, everyone. The Society of Petroleum Engineers is pleased to present this webinar, Patents in Oil and Gas, Offense versus Defense, by Peter Brewer. My name is Jeffrey Bailey. It is my pleasure to moderate today's webinar. I should introduce myself. I'm based in Houston, and I am a wells advisor with Brunel Energy. I recently retired from ExxonMobil after 32 years. As a principal drilling mechanics engineer, I specialize in bottomhole assembly design and drill string vibration modeling. In 2020, I was an SPE Distinguished Lecturer. My undergraduate degree is from Stanford, and I have a doctorate from MIT. I have over 30 patents, so today's topic is particularly interesting to me. Today's event will last around 60 minutes. We encourage you to ask questions throughout the event. Simply type them into the chat box, and please be sure to click the send button. Please do not use the Q&A, only use the chat box. Thank you for that. It is now my pleasure to introduce our speaker. Peter Brewer is a patent attorney with the law firm of Thrive IP. Peter holds a BS degree in petroleum engineering from Texas A&M University. Following a position with Gulf Oil Exploration Production in West Texas, he attended law school. After law school, he served as a briefing attorney to the Texas Supreme Court. Peter's practice focuses on patents, trademarks, copyrights, and contracts. Most of his work is in the energy industry. Peter is the owner of the website www.oilfieldpatents.com, and he is a native of Midland, Texas. So thank you for joining us today. Before I turn it over to Peter, I'd like to remind you to submit questions in the chat box as they come to you during the presentation, and then we will answer questions at the end. Now over to today's presentation. Hello, Peter.
Well, good morning, everyone, and welcome to this presentation. Our title today is Patents, Offense versus Defense. Jeff, can you confirm that you can see the slide?
Yes, looks good.
Very good. Well, as Jeff said, I have a degree in petroleum engineering. I worked for the old Gulf Oil E&P company, and then I did a very foolish thing. I decided to go to law school. Fortunately, I landed on my feet, and I have been privileged to work in the area of intellectual property law now for many years. And much of my work and many of my clients have come out of the oil patch. So hopefully there will be something here that will be interesting to each one of you. I should tell you that if you like this presentation and you're interested in more information, I wrote an SPE paper 2 years ago, a year and a half ago, and it's published as SPE number 210282. The SPE cut off a lot of my prized footnotes. So if you want to see the full article, send me an email. I'd be happy to send you a PDF file of the full article with the footnotes. All right, without further ado, where do patents come from? I suspect that some of you have been through the patent system and the patent process before, and you have a general idea of how all of it works, but I also suspect that a number of you have not been through the patent process. And so we will spend maybe 5 minutes just looking at a high level at what the patent system is. Patents come from a government agency of the United States government, and it's called the United States Patent and Trademark Office. It is a part of the Department of Commerce. This is their shiny building, and it's located in Alexandria, Virginia. This is the headquarters of the Patent Office. It's very nice. It's in a nice area. It's close to the Arlington National Cemetery. If you do take a trip to the nation's capital, there is a museum here, and it talks a little bit about the history of both patents and trademarks. Interestingly, this building was built in 1999, and before they ever moved in, they had already outgrown it. As a result, ever since 1999, a number of patent examiners have telecommuted, and it is very possible that you have a patent examiner that lives in your neighborhood. They are dispersed throughout the country by the thousands, and so many times when I talk to either a patent examiner or a trademark examiner, I'll ask them where they live. and it's always an interesting conversation. The Patent Office not only has headquarters in Alexandria, Virginia, they have various regional offices. The office closest to most of you is going to be in downtown Dallas. My impression is that most of those offices are there for public relations and recruitment of examiners. There's not a lot of substantive work that happens out of those offices. So, what is the purpose of the patent system? And when I give this presentation and I ask this question, the answer that everyone gives is to protect my invention. And that's not quite right. The government has a more altruistic purpose. It comes from our United States Constitution to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So there's a bargain that is made, and the idea is that if you invent something, you will disclose it to the public. You will tell the patent office so everyone can take advantage of your new technology, but the government will also give you a limited monopoly. And currently, the monopoly is 20 years from the date of filing. There are multiple reasons why someone will get a patent. The primary reason, of course, is sole source. You want that legal monopoly, but there are other reasons. It may be that you just don't want someone else to get a patent and then possibly sue you. So there's a defensive publication purpose. It may be that you don't intend to use your own invention, so you would like to license it to someone else and obtain a royalty stream. In my law practice over the years and the decades, I see a lot of that. Garage inventors come to me, will file a patent application, but then they'll tell me they don't use it, they don't make it, they don't manufacture it. They're just hoping someone will buy the patent rights and write them a check. Of course, there's always the issue of professional recognition. And then many companies, the larger E&P companies and service companies will pay bonuses to inventors, and typically those bonuses come in two stages. So the first stage is when you file the patent application, you'll get a bonus. And then the second stage is when the patent issues, and that ensures your cooperation through the entire process. Patents in the oil and gas industry, like many other industries, are driven by R&D. And if a company has a vigorous research and development program, chances are high they're going to have inventions and they're going to be retaining patent attorneys to protect those inventions. On the other hand, this has been my experience, if the price of oil drops, one of the first things that gets cut is R&D. Jeff, you can back me up on this. And so when that happens, then fewer patent applications get filed as well. What does a patent look like? Here's an old patent from 1911, and this is from a hydraulic drilling rig. I love the old pictures. The pen and ink drawings are always so detailed and beautiful. And the older patents, of course, were written by hand and filed by paper. And so they tended to be a lot shorter than they are today when we have computers that spit out lots of words. Here's a more recent example. This one came out, I believe, in 1939. It's a little bit hard to read. That's another oil derrick. All of the old inventions, and they go back to the 1860s in the oil and gas industry, relate to drilling, including offshore drilling. You'd be amazed how old some of the patent technology is. More recently, this is what the patent cover looked like. It's got the gold seal, the red ribbon, the signature of the director of patents. And of course, if we ever sued anyone for patent infringement, we would wave this around in front of the jury and tell them the experts at the patent office have deemed this patentable, and it's your job to help us to enforce it. And then finally, the patent office switched over to this new Jeffersonian form. This came out when the 11 millionth patent, I believe, was issued. But sadly, the patent office no longer mails out a hard copy of patents. All you get is an email and a digital copy. Each year, the Patent Office will generate an annual report. They call it an annual performance report. You can go online and it provides a lot of information, inside information about how many employees the Patent and Trademark Office has and how many examiners they have. So here's an example of a chart that's taken from the most recent annual report. And down in the left-hand corner, you can see that there are 8,000 patent examiners. And sometimes there's a lot more than that. That number fluctuates. It's an astounding number of examiners. And we need that many examiners because each year there are several 100,000 patent applications that get filed. And someone has to examine all of those applications. This will show you who the top recipients are for patents, and this is up to date. These are up-to-date numbers. This is 2024, and you can see that these are all electronics and telecommunications and semiconductor companies. Most of them are Japanese or Korean. No oil companies in this list, and only 2 or 3 American companies. Interestingly, you can see that these companies receive patents not by the tens or the hundreds, but by the thousands. And this is a pie chart that shows the number of patents issued by industry. The energy industry does make the list, but it's at the very bottom, and you can see that very small sliver of pie that represents the number of energy patents that are issued compared to all the other industries. And of course, the oil and gas sector will be a part of the energy industry. All of which is to say that I'm not minimizing, diminishing the role of the oil and gas industry in the world of patents, but we are a small player compared to pharmaceuticals, compared to semiconductors and other industries. So who are the top patent owners in the oil and gas industry? Well, here they are. This is the most recent list. Saudi Aramco is at the very top, followed by Halliburton, Siemens Energy, Baker Hughes. There are actually 2 universities in Saudi Arabia that are big patent holders in the oil and gas sector, and then ExxonMobil. What is most interesting is who is not on this list. You do not see Chevron, you do not see Texaco, you do not see Shell, you do not see Weatherford, and those were all major patent filers 20, 30 years ago, and they have fallen off considerably. It's worth spending just a second on patents versus trademarks. The Patent Office isn't just the Patent Office, it's the U.S. Patent and Trademark Office, but there is a big difference. So patents protect ideas. In order to obtain a patent, you must file a patent application. And it is a federal system and a federal system only. On the other hand, trademarks protect the designation of goods or services. They are an indicator of source or origin. Technically, trademark rights can exist at common law, but you're limited to the geographic scope in which you operate. If you want coast-to-coast rights, you should file a federal trademark application. Both patents and trademarks are managed under the same government agency. Also within the universe of intellectual property are copyrights. Patents and copyrights are also 2 very different things. Again, patents protect ideas. To obtain a patent, you must file an application. On the other hand, copyrights protect expressions of ideas. Examples include writing a book, writing a song, computer programs, statues, paintings. All of these things are within the realm of copyright. Hitting closer to home, if you write an article for the Journal of Petroleum Technology or anything that appears in One Petro, you will likely be required to execute at least a copyright license, if not an outright assignment. So, what will a patent do for me? And this is a question of statute. There is a United States Code, Section 35, that addresses patent rights. Patent gives its owner the right to prevent others from making an invention, using it, selling it, licensing it, or even importing it. Keep in mind, and the operative term here is as claimed. Your scope of your patent rights is limited to the claims that are in the patent. You will notice that the statute describes patent rights in terms of exclusionary rights. It gives you the exclusive right to make, use, or sell an invention. Don't be confused, though. It does not give you the right to necessarily use your own invention. You could still get sued by someone else because it's possible for your invention to infringe someone else's patent rights. I know that sounds bizarre, but patent rights have been described as a dog in a manger law. The dog will not eat the hay in the barn, but it will darn sure try to keep the other dogs out of the barn. And that's a good analogy for patent rights. Here's the front page of a more recent patent. This one issued in 2018 by my friend Bill Elmer. Bill lives in Tyler, Texas. And at the top right-hand corner, you can see this was patent number 10 million. So this was issued 5.5 years ago. We're already up to 12 million. So we're going through about 1 million patents every 3 to 3.5 years, which is an astounding number. In this case, you can see who the applicant is, who the inventor is, who the assignee is, who the proud patent attorney is. You'll also see even who the examiner is. And then finally, there's an abstract that describes the invention. So here's a dangerous question. Who owns my invention? Do I own the invention? Or does my boss, my employer, my investors? This comes up frequently with startup companies, the stockholders, and depending on the situation, the answer could be any of these. The general default American rule is that the inventor owns the invention. However, there are exceptions. If you are working for a large service company, chances are very high that when you stepped into the door the first day and you were handed an employee manual, that you were also asked to sign some papers. And one of those documents would either be an assignment of patent rights or an agreement that you would execute an assignment of patent rights if you ever invented anything. And sadly, in that case, your employer will own the inventions. So my advice is, if you have invented something, the first person you should talk to is a patent attorney, not your boss, not your grandmother, not the SPE. Call a patent attorney before you start talking about it, before you start publishing, and just see what your rights might be. So what should you do if you have an idea, an invention? After you've talked to a patent attorney, you should write down your thoughts, write down what the invention is, date the writing, create engineering drawings, or optionally build a prototype. It may be that your employer will ask you to prepare an invention disclosure form. They may already have a form for you in their system. I would abstain from writing and publishing an article until you have actually filed the patent application. I know the temptation is there to rush right out and sell or pitch the idea to a customer or write that JPT article, but you should wait and at least get the patent application on file. Question: who is the inventor? The definition is that the inventor is one who contributes substantially to the conception of a new idea. It is not the person sitting in the back of the lab who is conducting experiments. It's not the one in the fabrication or the machine shop that builds the prototype. It's not your boss. It's not the department head. And it's not the one sitting in the R&D meeting. It is the person who thinks of the idea. So in the context of an oil and gas service company, this is the way it frequently works out. You'll have a monthly engineering meeting. You'll talk about a problem or problems that are out in the field. You'll go around the room and talk about possible ways to solve the problem. None of those people are the inventor. It might be the custodian standing in the corner who says, wait a minute, the way to solve the problem is this. He or she becomes the inventor. It's the one who actually comes up with the new idea. There is a temptation from these engineering meetings to suddenly put everyone in the room down as an inventor on the patent application. It's always suspicious to me when I see more than 3 inventors. I will just throw that out there. What can I patent? So here's several slides. These are all tools and processes that I have filed patent applications for. I won't read every one of them, but you can see you can patent all kinds of things in the oil and gas industry. Hydraulic jetting systems in lieu of perforating casing, pneumatic pumping systems, an unseating tool for a downhole standing valve, rod rotation tools, sand screens, inflatable packers, reservoir simulation methods, even drill bits and pipe threads. Perforating guns, we do a lot of work in the perfing and fracking area, and even predicting casing failures. So you can see that the universe is wide and broad in terms of what you can patent in the oil and gas industry. So once you have your patent, what can you do with it? Well, remember, you have that set of exclusive rights. So you can manufacture the tool, you can use it yourself, become the sole source at OTC or ATCE or coil tubing or wherever your favorite conference is. You can manufacture it and then sell it to someone else as an OEM. You can license it out. You can do absolutely nothing at all. There's no requirement in the United States that you use the invention. You can wait until someone else uses it, and then you can sue them. That is not the law in Canada. In Canada, if you are not using the invention, then there's a mandatory license provision. Someone else can step in and use the invention based on a reasonable license. Or there are people that just want to get a patent to show their grandchildren. And then there are engineers that like getting those bonuses. Interesting question here. What happens if I change jobs? As you know, the oil and gas industry is highly mobile, and it's not unusual for a person to work 4 or 5 years for one service company, then go to work for another service company, then go to work for an oil company, then go to work for a startup company, then bounce back to the first service company. If you change jobs, you typically do not take your invention with you. You look to see what your employment agreement says. When you first conceived the invention, did you sign an execution or execute an assignment? So all of these things will need to be considered when you change jobs. If you are thinking about changing jobs, call a patent attorney, see what rights you might or might not have. And then once you have your patent, how do I enforce it? Federal courts have exclusive jurisdiction. Interestingly, most patent infringement cases are filed in Texas. They're filed in the Western District or the Eastern District of Texas, sometimes in Houston or Dallas too. But that includes oil and gas cases. It's very rare for an oil and gas patent infringement case to be filed outside of Texas. Only one claim needs to be infringed in order to prove patent infringement and to recover damages. The statute says that at a minimum, you get a reasonable royalty. Even if you can't prove lost profits, even if you can't prove that you were selling the product yourself, you can still get a reasonable royalty from the defendant. There have been 2 primary areas in the last 20 years where patent infringement litigation has taken place, and that's the frack wars and the perf gun wars. Originally, the service companies were suing each other vigorously over technology related to the fracturing of long horizontal unconventional wells. And then most recently, the litigation has been between companies that manufacture perforating guns. I should mention the rising use of trade secrets. Unfortunately, patent infringement litigation is the sport of kings. It can be time consuming. It can be draining on resources. It can be expensive. And so some companies, are thinking about just keeping some of their technology as a trade secret. And so that's something else you need to talk to your employer about. If you invent something, is this something that we want to publish? Is it something we want to get a patent application for? Or do we just want to keep it as a trade secret? And generally the test is if the product or the method cannot be reverse engineered, then you're probably better off just keeping it as a trade secret. Otherwise, file a patent application. I should also mention here the problem with covenants not to compete. All of you have probably executed one of those at some time in your life. The federal government does not like these. Many states do not like them and have found them to be void and unenforceable. Texas is not one of those states. However, I think the day is coming where covenants not to compete will be outlawed. We can also mention trade secrets versus patents. A trade secret does not have to be novel to be a trade secret. So that's a big advantage over the patent system. However, you do have to show that you make efforts in order to keep it a secret. In order to be valuable as a trade secret, it has to provide a competitive advantage. Classic examples of competitive advantage would be customer lists, manufacturing processes, chemical formulations, that sort of thing. If you file a patent application, it eventually will no longer be secret, will it? Because patent applications get published 18 months after the filing date and then eventually get issued. Wanted to mention just briefly the phenomenon called the provisional patent application. This is something that is unique to the United States. A provisional patent application can be filed on any idea, and it does not have to have all of the formal parts of a utility application. Theoretically, you could write your idea down on a cocktail napkin, convert it to a PDF, file it with the patent office, and you have the right to say patent pending. You'll get a serial number, you'll get a filing date, you'll even get an international priority date. The government filing fee is a whopping $300 or so for a large entity. And it is the best bang for your buck in the entire world for the patent system. However, it will not be substantively examined. It's simply a placeholder. And so within 1 year, if you want to take advantage of that provisional patent filing date, you will have to turn around and file the full utility patent application. And the same is true with any foreign filings. If you want a patent issued in another country, it needs to be done within 1 year of your provisional filing date, and that date cannot be extended. There are different schools of thought with respect to provisional applications. I see foreign law firms in Canada and the UK particularly, that will file provisional patent applications, and then they'll send it to me and say, can you convert this to a utility application? And the amount of work it takes to do that conversion depends on how much work the client or the foreign law firm has put into it on the front end. Some clients want to go cheap, just file a basic provisional application and spend the money later. At the opposite extreme is ExxonMobil, which has often asked that I complete a full utility application with a full set of claims and fancy formal drawings, all ready to be filed in the European Patent Office as an international application. It will be filed as a provisional application. It will just sit there for 9 or 10 months. Then they'll come back and re-examine it. And if they want to proceed with patent protection, they'll just take that provisional application that was written a year ago and file it. So it's a question of spending the money on the front end or the back end, or maybe a little bit on each end. The problem of public disclosure. The patent laws, particularly in the United States, are written in order to encourage inventors to file early and to file often. If you wait, you can lose patent rights. So in the United States, you must file your patent application within 1 year of any first public disclosure or attempt to license or attempt to sell, or I guess the classic example is the Rubik's Cube that sat on the man's coffee table. He had a Christmas party. He proudly showed it to all his friends, and he waited more than 1 year to file his patent application, and he lost his patent rights. So we tell people to file early and file often. Other countries are not nearly as lenient. Your own publications, your own YouTube videos can be prior art against you if you do not file your application before that YouTube video goes live. It is a harsh law. Selling a product can create a public disclosure. Testing a prototype. There's an example of an oil company that tested a drill bit in Wyoming. It was underground. No one saw it. It was still a public use. And it created a bar, a 1-year bar. So where are we headed in the oil and gas industry? Obviously, machine learning and artificial intelligence are becoming an important part of a lot of patent applications. But keep in mind that technology is just software. It's a tool. It's typically not the invention itself. You're still going to have some downhole tool that is using the machine learning or the artificial intelligence. I have a client that recently received a patent for a way of examining drill cuttings that come to the surface. And of course, he's got cameras and shale shakers and software and artificial intelligence, but the machine learning was not the invention. It was just a part of the tool. Geothermal operations. Interestingly, and as you know, as petroleum engineers, just about any invention can also be applied to geothermal operations. So when you write that patent application, you could substitute geothermal well for oil well. You'd have the same invention, just a different application. So, as a reminder, we try and throw in the reference to geothermal operations to many of our oil and gas patent applications. Drilling has become highly automated to the point to where, basically you've got a guy operating with a joystick and then another guy with the dope bucket, lubricating the pipe threads, and everything else is being run off of machinery and software. I'm overstating that, Jeff, but it seems like it's gotten that way. Safer perforating systems, every one of these long horizontal well bores that are now going out, 1, 2, even 3 miles, has a lot of perforation stages. And the handling of explosives, by the way, the regulations that govern the handling of perforating guns and those explosives is the ATF. They are considered firearms, ammunition, and they're very dangerous. And so safer perforating systems is a frequent topic for oil and gas patent filings. Anything that involves the Internet of Things, monitoring how your pump speeds, your pump cycles are doing, how your downhole pump and valves are doing. Carbon neutral operations, maybe those are falling out of favor, but they're certainly something that's been top of mind recently. Reduction of methane emissions, CO2 sequestration, and then the electrification of the oil field and the use of electric motors. All of these things, I would say, are where we are headed. You may be aware of other areas that are cutting edge, and I'd love to hear about them. So, Jeff, we've got some time now for questions. I went through that a little quicker than maybe I thought I would. So what do you think? I think you're muted, Jeff.
Okay, you hear me now?
Yes.
Apologize. So very interesting presentation, Peter, and we do have a number of questions that came in while you were speaking. So I'll take them in the order they were received. Nancy Zhao asks if an examiner is a full-time position in the patent office.
It is. You're not allowed to dabble in industry if you work for the patent office. In fact, there's also a rule that says that after you leave the patent office, you're not allowed to go and work for a company that files applications in the art unit where you were working. Maybe I didn't craft that exactly right, but there is a limitation on your ability to turn around and file patent applications and to work for a law firm and file applications back into the same unit where you came from.
Okay, so I guess that brings up the question, how is the patent office divided into units?
There are hundreds of units. So in my case, if you file a lot of patent applications that are in related technology, in this case, wells are in class 166. So most of my applications end up being in that class. So there are 4 or 5 art units that address wells and upstream oil and gas technology. So I tend to see the same examiners over and over. You get to know them, you talk to them on the phone. And fortunately, in the oil and gas area, there hasn't been nearly as much turnover as maybe in some of the electronics arts. And so, you know, I can see examiners I've worked with on these patents going back 15, 20 years.
Okay. Joel Shaw asks if you could elaborate on what you mean by counterclaim for infringement as a reason for applying for a patent.
Yeah, so it's called mutually assured destruction. My company has 1,000 patents and your company has 1,000 patents. And if you want to sue me on one of your patents, that's fine. I can sue you on 2 of my patents. So and this is particularly true in the semiconductor industry. We are in the business of splitting hairs, and we will file patent applications on the minutest, the smallest of incremental improvements of technology. The idea is that we won't be excluded from being able to use our technology that we develop. And if you do think we're infringing and you have the guts to sue us, that's fine. We'll file a counterclaim and sue you back. It's the sport of kings. So obviously it's not going to be a modus operandi for a small company that, you know, may have its, 3 patents.
Fred Newman asks, how do I proceed to get into the details of what the infringing company is doing and compare against my claims?
So sometimes that can be a challenge. When we file a patent application, we're required to meet an enablement requirement, which means we have to provide enough of a written disclosure in the application to enable a person of ordinary skill in the art to be able to use and understand the invention. But it doesn't happen that way when there's an infringer. You don't necessarily know if their method, if their process, if their tool meets every limitation in a claim. And so if you've got a good faith basis for believing that they are infringing, instead of running out and filing suit, it is possible to write them a letter and ask them and say, we have this concern. As a courtesy, we're not filing suit. Can you provide us, under a non-disclosure agreement with how your tool is operating? And a lot of times that's the best you can do. If they don't cooperate and you're still highly suspicious, I think you can file suit and pass a Rule 11 motion and demonstrate to the judge that it's a good faith filing.
Related question, while you're talking about infringement, can you discuss the difference between infringement of independent claims and dependent claims? Because, someone could, for instance, say, well, in my dependent claim, I specified X and I see somebody doing X, but they're actually technically, I guess, not infringing if they're not also infringing the independent claim. Is that true?
That's true if they're not infringing a dependent claim. or I'm sorry, if they're not infringing an independent claim, then there would be no way that they could infringe a dependent claim, since infringement requires that the method or the tool include each and every limitation that is in the claim.
Okay. Tamer Musa asks about software and web applications, complex area. What to do with the front end and back end? For example, in the back end, we have novel modules, and in the front end, we have novel interface and visualization tools. How would you protect this?
I would start out by protecting the code through a copyright application.
Copyright.
That would be a first step. Uh, if the software is being used in order to execute instructions for a monitoring system or to operate a tool, then you can file a patent application on the monitoring system or on the tool. But getting a patent application just for the algorithm or the routine itself can be a challenge. Patent Office does not like giving patents for what it calls abstract ideas or for scientific principles or mathematical equations. It wants to see a practical transformation of matter.
Okay.
So, for example, I once filed an application for a pump-off controller operating at the surface in order to control pump speed, and that was rejected as being an abstract idea.
Joel Shaw asks if, regarding trade secrets, can't someone externally patent something that you were keeping as a trade secret and then keep you from using your own invention, essentially?
That's a great question. Theoretically, yes. I think there may be an exception in the Patent Act if you could demonstrate that you were using the technology internally and you can prove that it predates the patent application. That's something I would actually have to go back and research in order to give you a more definitive answer to. It's a great question.
What is the most efficient process to investigate and pursue an apparent patent infringement?
You do the best you can with what you have. The thing you probably don't want to do is secretively and surreptitiously, break into the potential infringer's manufacturing shop or computer system or talk to one of their internal employees. You just have to look to see what's available online, or if you can legally purchase one of their modules or tools or devices, and then try and reverse engineer it. It's not always, an easy inquiry, but you do the best you can with what's available.
Karen Olson asks if you need a patent attorney to file a patent.
So I get that question from time to time, and the answer is no. You can file your own patent application if you think you can write it and file it and protect the invention that you want. But I also tell people you can do your own appendectomy, you can do your own root canal. It's just not a good idea.
Great examples. She also asks, what is the best site to search for prior art?
So, of course, Google has a patent database. It's possible to go into one of the online Google apps for patent searching and look for patent literature there. The USPTO website also provides a patent search platform. In my opinion, it's not as good as what it used to be. They made some changes, but you can go online with the USPTO website and search for patents. And then there's also the World Intellectual Property Organization, WIPO, and they have a database of patents worldwide. Of course, there's going to be limits. If the patent application is in Chinese or German, then you may only get an English abstract.
Yeah, the other day we were talking about freedom to operate, and You didn't mention onepetro.org as a place to search for prior art. So to what extent does art that's described in the SPE archives limit patentability?
Yeah, that's a great question. Of course, people outside the oil and gas industry, including examiners, a lot of times don't know that there's this universe of prior art out there through OnePetro. When we file a patent application, we do not have an obligation to go and conduct a search. You don't have to conduct a freedom to operate or a patentability search, and you don't have to report the results to the patent office. However, we do have an ethical obligation to tell the examiner about any prior art that we are aware of. So I caution clients against doing any prior art searching. I know sometimes in-house counsel find that strange, but ignorance is bliss, and it's just better not to know. When you file a patent application, you pay a filing fee, and part of that filing fee is you're paying the patent office to conduct a search for you. But it is true, if there is technology in some article that was written in 1968, as there frequently is, and you find that on OnePetro, theoretically it could kill a patent application.
Mhm. And for defensive purposes, if it's published in SPE and then someone files a patent and the publication came first, and this person with a patent then tries to argue that you're infringing, but you have an SPE publication, are you protected on a defensive basis?
Possibly. Obviously, if there was something that was published before the patent application was filed, then it would most likely be prior art. But again, we're in the business of splitting hairs, and so the owner of the patent will point out that there are features in the claims that are not disclosed in that 1978 JPT article or in that SPE paper. So, the chances of finding an old article that completely remove all claims are remote, but it's certainly worth looking.
Interesting. So John Muir asks, oh, sorry, let's see. Gideon Sarah asks, what are the main challenges that may arise when filing a patent for a new invention in the oil and gas industry? So what are the main challenges?
Challenges from the standpoint of the inventor or the patent attorney. So those are going to be two different things. I think from the standpoint of the inventor, the more work you do yourself, the more drawings you can prepare, the more words you can write, the more alternative embodiments and options that you can describe, then you're going to have a stronger patent application. You may also save your client a little bit of money too, because the more work you do, theoretically, the less work the patent attorney has to do. So I think that the biggest challenge is making sure that you have a full and complete disclosure of the technology in order to provide a basis and enabling disclosure for the claims. And keep in mind that when we file a patent application, there's an examination process that takes place. And oftentimes it's a process of give and take. So the examiner is not going to allow, for example, claim 1, but he or she will allow claim 4. If you'll move all the limitations of claims 2, 3, and 4 into your independent claim 1, then you can get a patent. And that happens very frequently. But it only happens if you have a good claim 4. And a good claim 4 comes because you have a solid disclosure and a thorough patent application that describes alternatives.
So related, Joel Shaw asked the question, what is the advantage of adding dependent claims when they're inherently more limiting than the independent claims?
There's several options. Of course, one, what we just described is the idea that if you file 20 claims, then you've got 20 chances for allowable subject matter. the examiner might not like claim 1, but he might like claims 5 through 15. And so you're going to have more claims. The next advantage is if you sue someone, it may be that they don't infringe the first claim set, claims 1 through 11, but maybe they do infringe claims 12 through 20. So you've got a backup there. And then finally is the issue in litigation. If your independent claim is invalid, but maybe the dependent claim is not taught in the prior art and it's still valid, and the infringer is infringing the dependent claim, then you still got them, because again, you only have to prove infringement of one claim.
So the question here sort of implies that a dependent claim is limiting the independent claims, and do you think that's actually the case?
That is not the case at all. So for example, if your independent claim is for a car that has a steering wheel and 4 tires, and then your dependent claim 2 says wherein that car is green, claim 1 does not require a green car. Only claim 2 requires a green car. So the dependent claims typically do not narrow and define the independent claim.
Great. So Julio Gitas asks, how do you see the use of artificial intelligence in patent analysis? Can we already trust AI for prior art searches?
That's the subject of another webinar. There are artificial intelligence engines, databases that promise to be able to go out and search the universe and find prior art for you. You just enter in the command, find me an article or find me technology that teaches a Christmas tree that has built-in lights and a wooden stand, and it will go out and search and find that for you. So that's actually a hot topic. Part of the DOGE process, it hasn't hit the patent office very hard yet, but the rumbling that we're hearing is that all of the prior art searching is going to be referred to artificial intelligence. And so a lot of employees at the patent office may lose their job. We'll see what happens.
Fred Newman asks, what is the average, if any, of the cost of filing an infringement case? What is the process one must go through after he or she notifies the infringer? And what if the infringer does not stop?
Yeah, so if you end up having to take the case all the way through trial, and assuming that there's not a re-examination request or an IPR, or inter-parties review process, you probably need to budget $1 million, and that may be low. But keep in mind that if I sue a company for patent infringement, they may challenge the validity of at least some of the claims through an ancillary process in the patent office. And that could add another $200,000 or $300,000 to the cost and another year or 2 of time. So it's not for the faint of heart or for the faint of pocketbook, unfortunately.
Question, if there's a patent in another country that's valid in that country, can it have global validity for the rights, is the question.
No, there is no such thing as a worldwide or a global patent. Patents are acquired on a country-by-country basis. So in the oil and gas industry, we will file a provisional application first in the United States. And then after we have our serial number and filing date in the US, we will send that same disclosure off to the countries of your choice. And in the oil and gas industry, that would be Canada, Norway, maybe Colombia, maybe Argentina, maybe Australia, maybe Ghana, maybe countries in the Middle East. Obviously, the more countries you file in, the more expensive it gets.
Karen Olson asks, what is the typical cost to file a patent application?
It completely depends on how complicated the technology is. and what's at stake. If you're writing a patent application for a service company, typically you'll have a negotiated rate. They're going to send you, 10 cases a month, and you agree to write those cases for $7,000 or $9,000 a piece. If you're writing them for an E&P company, they may have a slightly bigger budget. If you're in a small town and you're writing the application for a garage inventor, the chances are they may not have the budget for anything more than about a $6,000-7,000 application. But if there's a lot of mathematical formula, if there's a lot of chemical formula, if there's a lot of pharmaceutical options, I've heard of applications being $20,000 or $30,000. So it depends on the technology. And of course, that's just filing. Keep in mind, it's a 1 to 3 year process. So there will be additional fees down the road.
So if you were granted a patent, typically what is the amount in the schedule of fees that you pay to maintain your patent?
So every 3 to 3.5 years in the United States, we're required to pay a maintenance fee. And it depends on how many employees you have. But if you're a large undiscounted employer defined as a company that has more than 500 employees, your first year maintenance fee may be, I don't know the exact number off the top of my head, $3,500. And then your second fee will be more like $5,000 or $6,000. Then your third fee at the 11-year point will be closer to $7,000. And that's all you pay is those 3 maintenance fees. In other countries, they typically have a 1-year renewal fee. And so the fees are a lot lower, but you pay it every year.
Art Schroeder asked, can you address divisionals versus trying to get an examiner to keep all the original filing together?
Well, of course, a provisional is not going to be examined.
A divisional.
Oh, a divisional. Okay, yeah, that's a nasty question, because the patent examiners are financially incentivized. And don't tell anybody I said this. Financially incentivized to divide cases. So if I file a patent application and it has 30 claims and 4 sets of independent claims, the chances are very high that an examiner is going to send out a restriction requirement and ask me to elect, which one of these 4 inventions do you want me to examine? And then we have to file a response with an election of claims. And then if you want all of the other claims examined, which you probably do, you'll have to file divisional applications. Of course, the good news is that most of the work has been done, and now we're just filing the same application and asking the examiner to examine a different set of claims. You may have to do that 2 or 3 times, but you're not rewriting the application. The bad news and the frustrating news is that, now you have to pay filing fees all over again for each of these new sets of claims. And when the patents issue, then you have to pay maintenance fees for all of these additional patents. From the standpoint of the Patent Office, I can see their point. The law says, the Patent Act says, that you get a patent for an invention, not a patent for 6 inventions. So we're not going to let you file one large, long patent application and only pay one filing fee when you've got multiple inventions that are disclosed.
I think this is maybe the last question. John Muir asks, can you request a different examiner if you think the first examiner is being unfair or lacks expertise?
Fortunately, I haven't run into that hard brick wall of a recalcitrant examiner. Contrary to public opinion, the patent examination process is not adversarial. They are on your side. They want you to get your patent. They want you to get claims. They just want to make sure the claims are patentable. At least that's the politically correct answer. It is possible, though, and by the way, these statistics are publicly available. You can look online to see what the allowance rates for different examiners are. But if you find an examiner that you think is being unreasonable, you've got two choices, maybe three. You could call the SPE, what we call the SPE, the supervisory patent examiner. That's his or her boss, and ask for, sort of an informal appeal. The next option is you could file a request for continued examination and try and amend the claims and see if that goes through. Or you could actually file a notice of appeal and appeal to the Patent Trial and Appeal Board.
Great. Well, I knew we were going to have a lot of good questions and fill this time. And it was a very informative webinar. Thank you, Peter. On behalf of SPE, we also thank Thrive IP and Brunel Energy for their support of this engagement. And would like to acknowledge that today's webinar was supported and co-organized by SPE's R&D technical section and the Gulf Coast section. And thank you to everyone who attended. Some wonderful questions here and good discussion. Our next webinar is on 26th of March by Professor Roman Shore of Texas A&M University on open source drill string dynamic model. We hope to see you there. And this concludes today's program. Have a wonderful day and stay safe. And you may now disconnect.